Welcome to Adams and Reese's in-depth coronavirus guidance for school district administrators, brought to you by the Education Law team of Adams and Reese. I'm John Hooks, and I'm here with Jim Keefe, Elizabeth Maron, and KaShonda Day. This is our third update regarding the outbreak of the coronavirus and how it affects and impacts public school districts. We have pre-recorded this message at 7 o'clock p.m. on Thursday, March 19th, because of problems with the World Wide Web and internet crashing and phone conferences not providing the quality of sound that you all might need to take a look at all of these in-depth issues confronting the virus. Right off the bat, we want to get started by giving you all an overview of the state legislative and regulatory environment that we find ourselves in now, starting with the governor's executive order 1460 that came out hot off the press just today, House Bill 1647 sent to the governor and awaiting his signature, and also recent developments, and by recent I mean very recent, as in today's meeting of the Mississippi Department of Education. And Elizabeth, if you'll start off giving us an overview of the governor's executive order 1460.
Absolutely. Thank you so much, John, and thanks everybody for tuning in. The governor's executive order was signed today, March 19th, 2020. The major news in the order was a mandatory closure of public schools until April 17th, 2020. In this order, he addressed the 10-day issue with ADA funds that some of you are aware of, that is addressed in another statute. He actually suspended that 10-day limit, so school districts will continue to be able to use their ADA funds past the 10-day window. He also addresses testing requirements, and our discussion of the testing issue will also be covered when we talk about the state board meeting that occurred today. Key language in the executive order addresses continuing operations. Now, even amongst ourselves, we've wrestled with schools are closed. What do you mean continuing operations? Well, in this executive order, the governor gave directives that each school district shall continue to operate with essential faculty and staff, whether the faculty and staff are working from home, or in the workplace. And of course, if anyone is essential and required to be in the workplace for their duties, you must follow the guidance of the Mississippi Department of Health. Practice social distancing and hygiene, hand washing, all those factors that we are continually made aware of. Now again, this is to carry out essential functions, including the federally required programming. Lots of that comes into play with the special education students, and particularly globally for each school district, the development and implementation of distance learning or other instructional means necessary for students to achieve completion of essential grade level instruction for this school year. So this topic, this is something that we will try to address more in depth and sort of look at what each of these terms mean. As each school district, school districts will generally be addressing this differently. Some have some resources to push out more distance learning than others. It's going to require some creativity, and you may need a little time to ramp up to do this. The field is pretty broad in how you accomplish this, but it is something that each school district needs to contemplate how to continue student learning in an environment that has some pretty restrictive parameters.
And already we've been seeing a lot of examples coming into our office from all over the state. Jim, you've heard of a number of them even today of what school districts are doing to get really creative to try to address this imperative from the governor.
Absolutely, John. There are some districts that are technologically more able to roll out some of these services. Some are less able technologically to do that. We also have students with different needs. As you know, we have some students who are maybe on the borderline for graduation. We have students who are on the borderline for moving to fourth grade. But what we have to do, and we got 41 school districts, and I believe that it's going to look 141 different ways, but we simply have got to get creative and figure out how we're going to offer those services. And one of the things that we would do is to encourage you to talk with some of the districts around your area to see how they are addressing some of these issues. We realize it is absolutely not going to be easy, but I think what the governor and the legislature are looking for is a good faith effort by our school districts to continue what Elizabeth has just simply has gone through in the last few minutes, and especially in light of the fact, and we're going to get to it in a moment, about the legislature and the governor's willingness to maintain pay for our employees to the extent that we can provide those services for those kids. So talk to your fellow superintendents to find out what they are doing, and if things work for them, it may very well work for you. One example is defining work modules for some of your employees and some of the things that they can do. I know a lot of districts have already done that. Some have identified some very creative ways to roll out some instructional packages and information with their students. So there's no formula. Yeah, there's no playbook for this, and it's just up to each district to figure out what they can reasonably do.
And in fact, do we have any indication of how this completion of essential grade level instruction would be defined?
I think as we go forward, we'll look to MDE to provide some guidance with that. I think each school district also, you want to be giving some thought to what does that mean to your district? How do you look at your students and determine for your students what that would mean for each student? Some students have already completed their grade level requirements. The ones that are on the bubble, to use some of the testing criteria that we believe you'll be getting some relief from this year. And then, of course, the special education students, KaShonda is going to discuss the requirements with those students shortly.
Well, what are y'all hearing about this food service and transportation issue? The governor seemed interested in having school districts seems like try their best at doing something in the nature of food service. And we've seen a couple of school districts who have been rolling out some type of meal preparation program with varying degrees of success and varying degrees of creativity too. What insight, Jim, can you give?
We've had a lot of districts already do that. They've had cafeteria workers come in and prepare grab and go type meals. Transportation workers have come in to transport some of those out in the community, out to the schools. We have one district that has even had some churches, the volunteers locations as pickup locations. The federal government earlier this week relaxed the rules with regard to who you can serve. As you know, it initially were those on free and reduced lunches, and that's not the requirement anymore. We can serve any of those kids that are out there who need meals. We know that in many of the areas of our state, our families simply do not have the resources to feed their children. And so that not only was a directive from the governor, but that was a directive from the president as well. And I've been extremely pleased. However, I will admit to you, it is not the easiest thing to do. It takes a lot of work and effort. One of the good things about it, and we'll talk a little bit more about it later, it is employing our people to get this work done, which is certainly a positive.
We just saw one of our superintendents who put out a letter to his staff asking for volunteers for cafeteria work. And I think he had said, look, if you haven't been out of the state or the country in the past 14 days, you don't have a fever, you don't have respiratory issues, and you had a couple of other criteria. In other words, you're in reasonably good shape to come and possibly volunteer in one of the school's cafeterias, then he was going to try his best to launch into a feeding program based or depending on volunteers. We have seen some issues with cafeteria workers and some concern there in some school districts. Cafeteria workers seem to be of the age demographic that they have some concerns about falling into a category that they may be more susceptible. We encourage you to be sensitive to those issues and to try your best. And we realize not every school or every school district may have a food service program, but I think, as Jim said, what we're encouraging all of you to do is at least conduct the analysis of what's possible and at least make a good faith effort to move forward in this direction. It could be in only a couple of days we're having to pivot and alter different type of advice depending on what the pandemic, what direction it takes. But nevertheless, this is where we are today, and this is what we're encouraging too. The executive order also talked about just generally administrative leave with pay. What did it say about that, Elizabeth?
The administrative leave with pay, there were four different bullet points that it referenced. It said, if closed, well, we have to read that in conjunction with the earlier paragraph about essential job functions and continuing student learning. So while we are closed, there are continuing operations that some employees will be called upon to engage in. However, if you're closed, you have employees that there are no duties for, they are eligible to be paid, and Jim's going to talk a little more in depth about the administrative leave statute. Another bullet point is if the employee's duties are non-essential, and I've kind of mentioned that already, and you as the administrator, superintendent of the school have made a determination that an employee's duties are non-essential, and note in the order it says periods of time. So there may be a time period where, for instance, perhaps a payroll clerk. Well, when payroll is going out, perhaps that person comes in, that person becomes essential for a few days, however your operations work, and then would be non-essential for the rest of the month. Of course, if an employee or a member of the employee's immediate household is in quarantine or isolation as a result of COVID-19, that's kind of a given. And then there's a catch-all, other reasons as determined by the governing authority. And we'll come back to that in more depth in a little bit. But those are the provisions that were covered in Executive Order 1460.
All right, and then we also have some legislation that's come from the Mississippi legislature, a bill on the way, if not already signed by the governor, House Bill 1647. Jim, what can you tell us about that legislation?
Well, I think we all need to applaud our legislature and the governor for doing what they have done. The governor, I believe, will have signed this bill possibly by tonight, maybe already has. It's House Bill 1647. And Speaker Gunn, I think, introduced this, and then it passed the House and then went to the Senate, passed the Senate just overwhelmingly, and has been sent on to the governor. And this bill says that school boards are entitled to they may give additional administrative leave in order to keep our employees paid during the time period of this emergency declaration. And that is something that we were really, really hoping for, because obviously our employees need to know whether or not they're going to be able to receive any compensation during this period. Now, we have to be careful that we understand what the governor was saying in his executive order, and I think members of the legislature certainly would support it. The governor said this is not a time to consider being on vacation. All the employees who are continuing to be paid under this administrative concept need to understand that they are on call to be called in to perform specific duties in the discretion of the administration in order to fulfill those commitments that we're required to meet, that Elizabeth has gone over, those essential grade level instruction, the food programs, and things of that nature. So everyone has to understand they have a duty to be available to make that happen. We have two tensions working here, as you well know. The duty to make sure that we protect our families and society from this epidemic, And at the same time, we're trying to provide instructional services and food services and other services to the school kids and their families in our community. And so one of the questions that was asked of us earlier today was, would you define what is administrative leave under that statute? Well, if you go back and look at what Elizabeth just went over, administrative leave may be given for those 4 reasons outlined by Elizabeth a few moments ago. One, of course, the school being closed. Well, that has been done, but being closed means in light of our efforts to provide services to the students. The second one, again, was where duties are deemed non-essential. So, for example, if we have an employee who is not essential and is not asked to do any particular work at that particular time, that person may very well remain at home and still be paid. And then the next one was the period of time that the employee or a member of their immediate household is placed in quarantine or isolation. So that's a medical reason there. And then other reasons as determined by the governing authority in consultation with healthcare officials that are necessary to prevent a risk of possible transmission. So what this does is this gives the administration the ability to identify those essential employees to come in and to work and provide those services. If it means working from home, it might mean coming to school, but at the same time, maintaining the proper distances and following the proper protocols with regard to cleanliness and hand washing and so on, because no one wants to put anyone in harm's way. So with all of those things taken into consideration, the administration does have the right to be able to identify those folks who are necessary to get this done. Ideally, if we could have everyone work from home and show that they are performing work, then there's no need to have administrative leave. The administrative leave is to cover those 4 categories. So we know that there's been some questions about this that has come up, and a little bit later in our discussion, we're going to talk about some specific questions that we've already addressed regarding administrative leave.
Jim, what advice can you give maybe a local board attorney out there or someone who's trying to prepare a board order to take action for this administrative leave?
Good question. I think your board order simply ought to be a motion and vote, of course, on granting additional administrative leave during the pendency of this emergency declaration as needed by the administration to carry out those directives that were in the governor's executive order. I don't think you would want to put a specific number of days on it, because not every employee is going to need administrative leave. There are going to be employees who are going to be working every single day. There are going to be some that are going to be working maybe less than that. But the bottom line is all of our employees are going to get paid during this outage.
Now, there's a provision of this new bill that says that any employee on previously approved leave shall be eligible for such administrative leave. And I'll be honest with you, folks, this has created quite a lively discussion in our offices since we first saw this phrase come along, and we're still trying to get our hands around it to some degree. But at best, Elizabeth, you want to try your hand at explaining what we think this means and its impact on existing, for example, FMLA issues.
Just on its face, if you have an employee, for instance, out on FMLA, maybe they just went out 2 weeks ago and their FMLA paperwork says, has a 12-week time period of which they're going to be out. And maybe that employee did not have any built up personal or sick leave, so it's been an unpaid leave for them. Just reading this statute on its face, it now becomes a situation where they are eligible for this administrative leave, because the statute has a specific addresses that. They shall be eligible for such administrative leave granted by the governing authority. And the governing authority in this instance is the school board, directing the administration to implement these administrative leave provisions. There is another section, and this is the one that we really are going to have to parse through, and it says that the employee shall not be charged for his or her previously approved leave during the affected period. Again, we're going to have, none of us are really willing to say what that looks like right now. What we are saying, though, is that facially, if somebody is out on FMLA, they've used up all their leave, or maybe they haven't used up all their leave, they are now are eligible for administrative leave.
And then another series of questions came in today from our clients talking about the administrative leave to certain categories of employees. One had to do with substitute teachers and other part-time employees. Jim, want to take a stab at that?
Yes, if those are regular part-time employees, we think they're covered. Some of you use part-time employees who may be so sporadic, 2 hours here or 2 days there, 1 day this month, that type thing. Those we do not believe would be covered. But if you've got regular part-time employees, one district defined it to me as people who typically work 15 to 19 hours a week. We do believe that they would be covered by this law.
Also, a bit of news for everybody. Jim and I and Elizabeth KaShonda had a very in-depth conversation with the Office of the State Auditor today about those of the employees who work under your vendors out there, under vendor contracts. So let's say these would be the employees of Durham, First Student, of your food service provider, Chartwells, Valley Foods, etc. And we've learned that what we suspected, it's going to be all but impossible to provide payments to those entities during this time because, of course, that would violate the general notion that we haven't, that we would be paying for services not yet rendered. Jim, any thoughts about that?
Right. So if you have employees who work for you and also drive a bus under one of those vendor contracts, you're not going to be paying them for the time they would be driving the bus, but obviously you would pay them for the time that they would be working for you in some other role. We're going to mention a little bit later in our discussion vendor contracts in general and what happens when you're now unable to carry out that contract. And unfortunately, some of the contracts would have to be looked at specifically, and so all we're going to be able to do is just give you some general advice on those contracts.
And also, another prong of our new normal came today from the Mississippi Department of Education, and I think pretty much every educator in Mississippi breathed a sigh of relief to find out that the board voted to suspend all state and federal assessments, and the Department of Education was also directed to pursue federal waivers for suspensions of assessments and accountability generally. Of course, we have no idea what exactly that will look like, and we can't look into a crystal ball and determine how, if in fact school doesn't resume, or if it resumes a month from now even, what type of assessment would, if any, be possible to determine where students have academic standing. We don't know. A number of you suggested that they take the end third 9 weeks grade and start doing an assessment there. Questions have arisen already about, well, what do you do with those students who were right on the bubble and might need some additional services to catch them up to graduation or to grade advancement, if in fact there's an opportunity to do that sometime over the summer. So lots of questions with regard to those subjects. Districts will retain accountability results for another year, it looks like. And I think some of you, again, were excited about that, or at least to know you weren't going to have to figure that out in the midst of all of the current environment we're in.
John, let me make a comment on assessing students and where they are and whether they should pass and things like that. I think one of the positives that we're going to see out of all of this is that the decision on whether those children advance or not is going to be left up to the districts. And if you use, and I would suggest that you document very carefully, what you are doing to assess those children and those students and whether or not they have met the criteria for moving on. We've done that in the past, in prior years, before we got so dependent on some of the assessments that we now use. And I think we're going to be going back to that. But the good part about it is we have professional teachers and educators who absolutely can determine whether or not someone is ready to move on to the next grade or someone who is ready to meet graduation requirements. You may have some issues where maybe some coursework needs to be completed for kids that maybe are in a particular block and they haven't had a chance to take that course. We're going to have to get creative about how to do that. And we've already heard a lot of good suggestions, even for those districts that don't have technology for online learning. So anyway, I think that's one of the positives, believe it or not, that I think will come out of this, is that we'll have the freedom to make those kind of decisions. Now, obviously, we're going to have to get guidance from NDE in this regard.
Well, and also we had a couple of days ago guidance coming out from the Department of Education having to do with special education population. KaShonda and Jim gave an amazing, in my opinion, amazing, because it demonstrated how complicated the subject is and how much they know about it, presentation regarding special education guidance and all of the issues surrounding and revolving around special education students. KaShonda's here to give a brief overview of the guidance and the impact on it. KaShonda, tell us what happens if a school district provides some type of educational services to regular education students.
Yes, John, and you are correct. This is a very complicated issue, but if a school district has decided to provide education services to its general ed students, then it must provide services to its special education students. I know a lot of districts are going to a virtual online using that as a resource in providing online instruction and virtual instruction using various tools. Keep in mind that if you make that available to your general ed students, you must make that available to your special education students. And I want you to consider two things. Consider equal access and individualized services. You must provide equal access to your special education students, and whatever you provide to your special education students, it must be individualized to meet their unique needs. Now, what does that look like and what does it mean? Does it mean that school districts are tasked with having an IEP meeting for every student who has an IEP? Maybe, probably not. I've advised some school districts to consider making amendments to your students' IEPs. Of course, that's a process, and it's not an easy process, but it's probably a lot easier than having 1,600 IEP meetings. So what you would want to do, you have to look at each individual student's IEP and make a determination on what you can provide and what you can't provide during the school closure, keeping in mind that you're likely not providing a full range of services to your general ed students. And that probably means that you're not responsible for providing a full range of services to your special education students. But what I would advise you to do is to look at each individual student's IEP, determine what amendments need to be made to that IEP, call the parent, let the parent know what the proposed changes are to the IEP. Ask that parent, are they willing to agree to those amendments, to those changes, without conducting a full IEP committee meeting? If your parents are willing to do that, and of course you need to have everything, every agreement documented in writing. If your parents are willing to agree to those changes without an IEP meeting, then you use the IEP amendment form and you make those changes. Provide the parent with a copy of that amendment form, and you have to provide your parents also with a prior written notice. And so that's probably an easier process. Of course, if your parents don't agree to the amendments without a meeting, then you're likely responsible for having a meeting. And you don't have to have an in-person meeting. You can have a virtual meeting. You can have a meeting via teleconference. And so you do have those options, and both the Mississippi Department of Education and the United States Department of Education have made that clear in their guidance.
Would either of you two SPED experts be surprised to see in the coming weeks some type of legislation from the U.S. Congress or additional guidance that would somehow take into consideration the dilemma school districts find themselves in?
Absolutely. I know we've received many questions from SPED directors who are in the middle of reevaluations and even initial evaluations. And of course, we know a lot of those evaluations are time sensitive. And so I do expect in the coming days or week to see some guidance on whether or not those deadlines will be waived. Jim, do you have any?
Yes, I'm aware that the Council of School Attorneys, which is part of the National School Board Association, has sent a formal letter to the U.S. Department of Education asking for clarification about waiver of deadlines, requirements to meet FAPE, what other requirements are they going to be held to, or what waivers are going to be granted. And as you know, this is a nationwide issue. It's not just affecting Mississippi. So we will probably get some guidance in the near future. But I think KaShonda's advice is so good that you simply look at each individual child. And I've heard nothing but some positive comments where parents have been surprised that they got a call about their child from the teacher and other administrators inquiring about their child and what they can do going forward. And the results that I've heard preliminarily is that parents have just been extremely accommodating and understanding about some of the things that can and cannot be done. Keep in mind that once we get back into school, we'll be looking at what's called compensatory services of some nature, but there we're looking at loss of skills and not just simply loss of services, because some of the kids may not need much at all, but that's of course going to be another issue for another day. But in the meantime, individualizing that effort and documenting that effort, I think, is going to be key.
Right. And Jim, you mentioned compensatory services, and I would just imagine that if you're not providing the full range of services during this closure, then you're probably going to have to look at each child's IEP and make a determination as to whether or not compensatory services are warranted. So just keep that in mind. And as Jim stated, compensatory services are not always warranted. It's not just a matter of services not being provided, but it's whether or not there is any type of loss because the services were not provided. So just keep that in mind.
Lots of moving pieces on the SPED front. And I would say, I think special education, we all agree here, is probably the most complicated aspect of this entire COVID-19 outbreak as it affects public schools.
It really is. And I'll bring up a question that has come up, and we need to go ahead and address this, and I'm going to ask KaShonda to weigh in on it as well. Several superintendents have indicated that they just simply do not have the ability to offer quality educational services for their regular ed population, which means they would not be able to do it for their special ed population. So what they are doing is providing educational packets and information that maybe are remedial in nature, non-graded, packets of information to help parents know what to do with their children during this break, and just some pointers and things of that nature. So it's non-instructional type services. And the thinking is, well, then if I don't provide instructional services to my regular ed students, then I don't have to do that for my special ed students. I can provide them generally the same kind of packets of information that I am providing my regular ed population. And KaShonda's had some discussion with MDE representatives, and while we don't have a definitive answer, we can certainly give you what our thoughts are. KaShonda?
Yes, Jim is correct. I have had some discussion regarding this particular issue. And the way I described it is optional enrichment packets that are not graded. They're completely optional, not tied to any instruction or any curriculum. What I've been told is that in that situation, the IDEA would likely not be triggered, but just be very careful and cautious with your instructional package. You have to be very careful. And in that situation, even though it's optional, you still may want to look at each individual student's IEP. And if there are any accommodations or modifications or any pointers that you can give to parents in helping the students complete these packets, you should probably err on the side of caution and provide that parent with that information. But again, what I've been told, and as Jim said, there's really no definitive answer on this, but what I've been told is that if it's an optional enrichment packet, it's not graded, it's not tied to any instruction or any curriculum, then the IDEA may not be implicated. But please err on the side of caution and look at each situation on a case-by-case basis.
One thing I would reiterate, go back to paragraph 2 of the governor's directive that mentioned the effort to try to achieve essential grade level instruction. And so if the governor certainly expects us to try to do that. And if we possibly can, not because it's just hard or difficult or it may be on a very limited basis, but if we can do that, then we should try to do that. And we should also try to do what we can, even though it may be on a limited basis for our special needs children. But I think if KaShonda mentioned that one word that you need to remember is called individualized for these special needs students. And if you decide you're not going to provide those services, I still think it would be very, very important to have that contact with that parent and let them know that their special needs children are not being forgotten in this process.
Yeah, parental contact seems to be something that our superintendents we've spoken with and other district administrators around the state say is really getting a lot of positive response from the school district communities. They indicate to us that the more contact, the better. And in some instances, if teachers who are now on administrative leave and they're sort of hunkered down, waiting out the storm here, if they can at least pick up their grade book and begin calling and checking on students, checking on parents, that seems to be something that's resonating throughout various communities where you serve. Also, the U.S. Congress has been busy passing federal legislation. There are two main acts here that came about, or two provisions passed yesterday that affect school districts, and one has to do with the Emergency Family and Medical Leave Expansion Act, which is just what it says. It's an expansion of the Family Medical Leave Act. And as many of you know, FMLA is exceedingly complicated in the employment arena. And here we have something that is not surprising at all, adding to the complicated drama of the Family Medical Leave Act. The second was the Emergency Paid Sick Leave Act. And both of these pieces of legislation, I think, have to be sort of situated in the light of the paid administrative leave that Mississippi finds itself in for its public school district employees. Jim, what can you tell us? I know this was just passed yesterday and we're still parsing through it, but what can you tell us about the Emergency Family and Medical Leave Expansion Act? What did it amend the FMLA to provide?
Okay, a couple of things. First of all, the Emergency Paid Sick Leave Act is an act that was geared toward the COVID-19 issue to provide a limited amount of paid leave for up to 2 weeks. And then, of course, because mandated paid leave is not a nationwide law. But for this particular situation, it's a temporary law that is going into effect, I believe, on April 2nd and will expire December 31st or at the end of the year. And the other was an amendment to the FMLA law. And as you know, FMLA, as it is written today, is unpaid leave. Well, under this new law, it grants up to 10 weeks of paid leave, with the first 2 weeks not being paid. Now, here is the fortunate situation that we find ourselves here in Mississippi. Because of our administrative leave bill that was passed, what we provide our Mississippi workers is better than either one of those two laws. So we think that our workers, by being paid under the administrative leave law that was passed, would mean that most of our employees will probably never even have to take advantage of either one of those laws because they're going to be paid under that other law. Now, what we would suggest that you do is that if you do have a specific FMLA-related question, go ahead and email that to us. We will be giving you an email address to send your questions, because we know that because of the way this format was tonight, you don't have a chance to send them to us during the course of this conversation, but we will continue to monitor those questions and maybe put out a Q&A with some answers to those questions going forward. So all those FMLA questions are fact specific, and we would certainly be willing to address those. But that's basically it. But our legislature and our governor has put us into a good posture with this administrative leave law. And
we did have an opportunity, knowing that we were going to have to record this, to solicit some questions from y'all, and we've got a stack here. We're going to run through a few of them. Elizabeth's got a couple of questions that might apply to the whole group here.
Okay. One of the questions, do we have to document work from home? Now, with your hourly employees, they absolutely need to be keeping time records. I don't know the level of sophistication with regard to the timekeeping system. If they cannot clock in remotely, you will want to have timesheets to keep track, and also put out a mandate that no one is to work over 40 hours per week. And that it's one of these things where they have to get pre-approval for any work over 40 hours, because we really have to still keep track of that. Now, it's our expectation that your hourly employees will not be working the full complement of hours, even the ones that are deemed essential. So, but if they are working and they're hourly employees, we need to keep track of their time. What about the teachers, the exempt employees? In light of the directive to continue providing education, having an idea of what your employees are doing in order to further that mission would be great. It's not required, but I think it's a good idea to keep just be able to convey and articulate what it is your district is
a running
doing.
Tally of your efforts and successes. And also, I think, too, to add to what Elizabeth said, I know a couple of superintendents have been keeping more or less a journal of all the things that they've been doing to, for example, assess technology in their district. So some have done very brief, very simple technology surveys to just find out what exactly students have access to. If they don't have a Chromebook to give everybody in the district, well, how would you find out how many of your students have access to the internet at home, for example? Some of you have kept track of your conversations that you've had, various consultations with state department or local county public health officials or doctors that you may call, and so on, to determine, for example, whether it makes sense for you in your particular school to have a cafeteria feeding program. So there are a number of things that you've done. Also, a number of you have done some pretty sophisticated investigations already just in the last week or so of online platforms that are out there. Some of you have even come across some things that you think may be beneficial going forward long term, that you're more or less excited to get involved in and see a future even after all of this passes over. So if you can keep track of those things, if ever you're called on by the legislator or the governor and so on, I think it would be a good idea for you to have those. And incidentally, speaking of those things, when you see your legislator, you probably want to thank your legislator for the legislation that's come along and for paying public school employees for this, and give them a brief update on what you've been doing. Show them that you've been trying your best to comply with these things. Now, we know, as it was mentioned on the Department of Education conference today, there was, I thought, a pretty candid admission that many of you are not going to be able to provide some of these services and comply with these directives for a variety of reasons, whether it's lack of technology in your district, whether it's your concern of inequitable distribution of these throughout your district, or whether in some instances you may have already had some cafeteria workers who've succumbed to one form of illness or another or in quarantine. Whatever the case may be, there may be impractical realities to that. We think it would be helpful for you to document what those are and keep a list of your various concerns and your efforts to at least comply and show that you're attempting to move forward with these directives as best you can. Any other question, Jim?
Yeah. In anticipation of this call, we had we called the state auditor's office this morning, Shad White, and he called us back immediately, and we asked him would they be available for a conference call to discuss some of these issues before our meeting tonight. Within 45 minutes, Shad White had about 5 or 6 members of his staff on a conference call with us discussing these issues and what this administrative leave law really meant and how it was to be applied. And they gave us some really good examples. For example, you may very well have an hourly employee that you call in to do some work, and they normally work about 5 hours a day, but you bring them in and they only need to actually be there about 3 hours. But the fact that they're there, they're ready, willing, and able to work that 5 hours means that they're going to get paid their full wages, because not only did they work part of it, but the rest of it would be covered by this administrative leave law. So was very, very encouraging, and they were very encouraging that since this law was passed, this administrative leave law is going to enable us to keep people paid during this emergency declaration. Now, what is clear in this, though, and this question has come up, and we might as well face it, some of our employees who have been working and have been paid because they are essential employees have inquired as to whether they're going to get another day off as a result of them having to come in and work, while some of their peers may not have had to work, and are they going to get compensated another day for that? And the answer to that is no. The reason is they are essential employees. They're being paid for the work that they are being required to do, and those people who are not being paid simply are being covered under the administrative aspects of that law, that administrative leave, by virtue of the fact that we do not have the work for them to do. Obviously, if we have work for someone to do and we ask them to do that and they say no, they're not going to do it unless they have a medical reason, or they fall out of, or they can give us one of those 4 criteria for not being able to do that work, then obviously that's a different situation. That employee would be expected to do that work, and an employee like that would not be paid for refusal to do that work. But those are going to be very, very difficult issues, as you well know, because I believe most of our employees or all of our employees, I believe, will be more than willing to work if we simply provide them the opportunity for it. But my point in that is that the state auditor and their staff gave us some really, really good advice and direction on that today, in terms of helping us interpret the effect of that particular law.
Jim, we've had a couple of questions too about getting contracts out to employees. Some districts are sort of in the middle of that process, and then we also had some questions about getting contracts back. Any thoughts on that?
Absolutely. As you know, your requirement when you send out your contracts is that employees have 10 days to get that contract back in, or at the discretion of the board, that contract can be deemed to be null and void. What we suggest is that if you go ahead and send those contracts out, you can certainly do it. There's no reason not to. But you've got to be able to make sure that you have communicated with the employees so that you know that 10 days is running. But once that 10 days is up, then I think it would be paramount for you to contact those employees in some way. Now, the question has come up to us is, okay, what if someone can't scan the document and sign it and get it back to you? I think there are various ways that we can verify that they have signed that contract. Most people have a smartphone. They can sign it, take a picture of it, and text you back that signature page. If they can scan and email it back, fine. I think if someone sends you back an email stating that they have signed the contract, I think we can accept that as well. So we're just going to have to be as practical as we can to make sure that our employees have the ability to execute those contracts. I would not be hung up on the 10 days. And remember, the contract is not ruled null and void until the board actually meets and rules it that way. So it may take several weeks for that to even happen. So just be flexible. If you have an employee who says they're not coming back, get that in writing from them, and then you can move on that as well.
All right. Sounds like smoke signal, carrier pigeon, any way you can get it back. Elizabeth, what about non-renewal dates and deadlines?
Okay, well, the next deadline in the statute is April 15th or 10 days after the governor signs the appropriation bill. So you have some options here. You can go ahead and work toward the April 15th date, or we know the legislature's they're taking a break as well. So the appropriation bill is a long way off from being approved. So again, though, keep your processes going. If you've already identified people that were going to be non-renewed, you still have to, if you offer them a hearing, if they meet the qualifications to receive a hearing, you have to show your legitimate educational reason. You still have those obligations that you normally would. With your first year people, they are not entitled to a hearing. Still, though, and there's the idea that you don't need to offer them a reason, but for practical purposes, you want your best evidence to show why it is that you're not bringing that person back. So again, you've got some flexibility on that date now, but just don't be caught flat-footed when the time does come and the appropriation bill is signed. You want to have all your ducks in a row and ready to go on those employment decisions. We may have issues with, well, I was trying to work on my improvement plan, but I couldn't finish because we got our school got closed. So those are going to be discretionary issues for you to be prepared for in that case. So those are some non-renewal issues, and I'm sure, again, we welcome questions that point out to us things you're wrestling with on those issues.
One thing you can also do when you send out that non-renewal notice, and you're all doing it anyway, you can always give the employee the opportunity to resign rather than have a non-renewal on their record. And then the question becomes, how do you document the fact that they would rather do that? And that's the same documentation we talked about a little bit earlier. Once you get a signed statement from them that they would rather resign and they're submitting their resignation effective at the end of the year, as you know, you have to have the school board approve that resignation.
And I do want to mention one other thing, and we have to play this out. If an employee does request a hearing, you have your 30-day window to provide a hearing. This part of the statute does sort of mitigate in favor of waiting till waiting till after April 15th, because at this point we don't know when we're going to be in a position to all sit in a room and have a hearing. So be aware of that. If you do issue your letters, your non-renewal letters, those time frames will kick in, and we will have the responsibility of providing a hearing within the 30-day time frame for the employees that are eligible for hearing. So with that being said, I would wait until after April 15th, and I would watch for the appropriations bill.
A lot of questions this week from districts who have various aspects of the operation still going on. Maybe it's a skeleton crew here or there, and they're questioning employees about certain health conditions that appear to be related possibly to COVID-19. I know many people out there listening will realize and know that the ADA regulations have changed and been altered in some instances dramatically, in some instances slightly, since the time that the World Health Organization declared COVID-19 a worldwide pandemic. So, Elizabeth, what can you share about that generally, or Jim or KaShonda, any thoughts on just generally dealing with an employee who, for example, says, I think I might have been exposed, or I've got a fever today, et cetera?
Well, as I said earlier, I think every inquiry is fact-specific, and you're going to have to look at each case individually and on a case-by-case basis. What I would advise you to do is to be consistent with whatever you do. And
And I think what generally one of the features of ADA is that it expands to some degree the type of questions that an employer can ask an employee in a pandemic. Obviously, we're trying to figure out what's wrong with employees and so on, but I would remind everybody there's still some pretty intense privacy concerns here that affect employees and your students as well. So if you have somebody who comes down with COVID-19 and they're hospitalized and so on, be careful about how you indicate that to your school community, because you want to preserve the employees or certainly the students' privacy interest, while at the same time you want to also make sure you've covered your basis and you've notified people about a potential exposure to an employee. So there's a very delicate balance here with regard to how to handle employees. Some of you have also had some questions about employees who may, for whatever reason, indicate to you a hesitancy about coming to school. We've had a number of questions surrounding that, and some say, for example, oh well, I don't feel comfortable coming up to school because I've got this underlying illness that has to do with my immunosuppressed, health situation, or might have had a transplant of some organ some time ago or surgery, et cetera. So I feel afraid about coming to the school. Any thoughts about that, team?
I would think in a case like that the employee does have a duty to give us medical documentation to support that. I think once we get that medical documentation, then we can make a decision on how we're going to, what position we're going to take. I know that most of us would probably err on the side of being safe rather than sorry, but at the same time, I think we just kind of take that ADA approach of, okay, what is it that is medically causing you to feel this way? Because a lot of people, and we all know this, a lot of people have a heightened concern that has no medical basis to it, but we also have people who have legitimate medical concerns. And I think we have a duty to try to separate those out. Do you guys agree?
And I just, again, wanted to emphasize the privacy aspect of this that John mentioned. If you have an employee or student that's diagnosed, you are not, with COVID-19, you are not allowed to say that person's name. There's a protocol that you do for checking in case that person has been in your building. And again, that's probably a subject for another call. But the privacy and the name of the person diagnosed does not need to come from you as the school district representative. Well,
and I think getting back to the basic tension that Jim identified earlier on, there is a tension here between the school district's desire to do something to provide for at least some level of education to the students out there, and the tension that you're going to get from the pushback you're going to get from some of your employees. And some of them are going to be creative in some of the things that they say. They're either going to say they have some type of illness, some kind of fever, some type of respiratory problem, or they may say someone at home has it and they believe they might have been exposed. If that's the case, then you really are in a hard spot, because some of these tests, we understand, take 2-3 days if you can even get one to get back. So you've got some confusion there. And then when they say they have an underlying immunosuppressed illness on top of that, you have some difficulty in interpreting that and so forth. So you're going to find yourself in a difficult spot when employees begin to indicate an unwillingness to perform some of these duties. And as Jim said, we're going to have to tread carefully. And I think the time, as I always say, stop, drop, and roll, and not let your temper and your emotions get away with you with some of these employees, because ultimately, they may be the ones who's sort of priming the pump for some kind of litigation down the road, and we want to assume that people are acting in their best disposition at this point in time. But I would encourage you all to involve your local board attorney. Certainly call one of us if we can help you through some of these trickier employment issues, and to recognize that these are unprecedented times where a fresh look at some of your employment actions are probably warranted. And it could indicate, or could end up being, that at the end of the day, one of the practical realities that you're confronted with as a superintendent is a management problem where employees increasingly find or indicate that they're not willing to actually come to the school, but they're continuing to perform services at home. So you're going to have to continue to sort through that.
John, we have a question that came in today, and this is one of those practical questions about delivering services. And the question is, can a teacher read a book on camera and then put the video on YouTube? And I think we have some problems there with copyright violations that would have to be addressed. One of the questions that we also got was not even putting it on YouTube. Is it a violation if a teacher uses social media mechanism to read to a group of students? I feel more comfortable with that being allowed because you're not copying it. You're simply reading material that you're using in your instructional practice with your students. But I do feel very comfortable saying you could not record that presentation and then put it on YouTube. We have some intellectual property experts in our law firm. We're going to run a lot of these questions by them, because we also had the question about, well, what about copying materials and sending it out to students? Do we have a copyright problem there as well? So we're going to get clarification on those issues, and we'll get that out to you.
Yeah, lots of moving pieces. Any other thoughts, final thoughts? Well, we're going to be continuing to provide these updates in some format or another as we proceed, trying to get our hands around and deal with many issues that confront public school districts and the mighty efforts that many of you are going through to continue the great work of educating Mississippi school children. If you have questions as this process develops, don't hesitate to let Jim Keith, Elizabeth Maron, KaShonda Day, or me, John Hooks, know, and we will try our best to answer your questions. I think one of my superintendents said it best today. We're all in this together. So let us know if we can help in any way. We are your education law team at Adams and Reese, and we have appreciated and enjoyed the hour we've been able to spend with you. Thank you.